Good afternoon, everybody. My name is Diane Amon. I'm the Emily and Ernest Woodruff Chair in International Law here at the University of Georgia School of Law, and I'd like to welcome you to a very special event, a discussion by Ambassador Scheffer about war crimes tribunals. Before I introduce him, I'd also like to thank and welcome you on behalf not only of the law school, but also of the law school's Dean Rusk Center for International Law and Policy, which is a sponsor of this event, and special thanks to the Students' Georgia Society of International and Comparative Law, which is also a co-sponsor of the event. For students in the audience, I'd like to recommend to you the Rusk Center website and invite you to look into the programs of the center, including our summer study abroad programs in Beijing, Shanghai, Brussels, and Geneva. And I'd also like to welcome all of you to return here next month for a very special event. There are flyers around, and I'd welcome you to take one home with you. Judge Joan Donoghue, who is the American judge on the International Court of Justice at The Hague in the Netherlands, the so-called World Court, will be delivering the annual Sibley Lecture of the Law School at 3:30 p.m. on Tuesday, April 3rd. Without further ado, let me tell you about David Scheffer. I'm delighted that David was able to come join us today. He's been a colleague of mine and someone whom I have, whose career I've watched and respected and admired from afar for a decade or two. He is currently the Mayer Brown Robert A. Hellman Professor of Law and the Director for the Center for International Human Rights at Northwestern University School of Law. He was, in the 1990s, the first ever ambassador on war crimes issues in the State Department, and worked in that capacity and in other positions throughout the 1990s as really the point person in the United States on bringing people to justice who were suspected of having committed war crimes. And so in that capacity, he was hands-on with regard to the establishment of the Yugoslavia War Crimes Tribunal, Rwanda, Sierra Leone, Cambodia, and he was the chief negotiator at Rome for the United States at the conference that led to the establishment of the International Criminal Court. Since leaving government, he has served as a law professor, and he has just been appointed by UN Secretary General Ban Ki-moon as the United Nations special expert to try to jumpstart, if you will, again, the accountability process in Cambodia. He has just completed a really wonderful book. As you can tell from my markers here, is a lot to read that one must remember. It's called All the Missing Souls, A Personal History of the War Crimes Tribunals. It's really a remarkable book to chronicle that period from the inside, something that anyone who cares about these issues, anyone who cares about how foreign policy is made in the United States, anyone who cares about international criminal law, I would commend that to you. And without further ado, I'm going to welcome David to come talk to us about his book and a talk that he's entitled The End of Impunity, War Crimes Tribunals in the 21st Century. Thank you.
Thank you very, very much, Diane, Professor. And also I want to thank the Rusk Center and Professor Johnson and everyone else who is associated with the University of Georgia. You know, there's someone here today who deserves your special applause, and that is my driver, Spencer, who's right there. This guy drove for 2.5 hours through a lot of weird traffic to get to the airport this morning to get me, and then the drive back was an hour and a half. So it was an easier thing. But Spencer, I'm incredibly indebted to you. So thank you very much. Okay. Well, this is a great pleasure. I think I actually spoke at the law school in the late 1990s while I was ambassador, because I remember so well the vision of the law school and the courtyard and the beauty of Athens, Georgia. So when I was invited by Professor Amen to return, it was an automatic yes. So I am extremely honored and privileged to be here today. I hail from Oklahoma, and I feel like when I'm in Georgia, I see some of that same beauty and generosity of spirit, and just I love the campus corner, just like the one that I grew up with back in Oklahoma. So it's a great pleasure to be here with all of you. What I want to do today is I want to talk about some of the larger contextual character of my story in my book, All the Missing Souls, and some of the details within the book itself. And then I want to read a few passages from the book for you, which might interest you. And then, of course, take your questions, because typically these discussions become most interesting in taking your questions, particularly about the contemporary challenges that are confronting international justice today. I only need mention Syria, and you get what I'm saying. So there's a lot of stuff out there to ask me about. And the reason I say that is because this book that I've written resonates in contemporary international politics and law. Understanding why the highest political and military leaders are increasingly at risk of indictment and prosecution today, and why the mission of accountability grows with every passing year, requires looking back at least to the 1990s, when, as I write in the book, one of the most ambitious judicial experiments in the history of humankind, a global assault on the architects of atrocities, found its purpose as mass killings and ethnic cleansing consumed entire regions of the earth. The grand objective since 1993 has been to end impunity at the highest levels of government and the military, not only for genocide, which captures the popular imagination with its heritage in the Holocaust, but also for the far less understood offenses of crimes against humanity and war crimes. The building of institutions of international justice has had a lot to do with that new reality, namely that impunity is on the losing side of history now. Understanding why Muammar Gaddafi and his son Saif al-Islam were indicted by the International Criminal Court last year, why Sudan's current president, Omar al-Bashir, was indicted for genocide in Darfur and defies to this day the authority of the same court, why Radovan Karadzic and Ratko Mladic are finally standing trial in The Hague before the Yugoslav Tribunal, why former Liberian President Charles Taylor awaits the judgment of the Special Court for Sierra Leone, which will be handed down on April 21st, why 3 of the surviving top Khmer Rouge leaders of the Pol Pot regime are on trial today in Phnom Penh, and why the United Nations and the U.S. government are focusing more of their attention on atrocities prevention strategies today, takes us back to the 1990s, when major failures occurred in reacting to atrocities, when the 5 major criminal tribunals were negotiated to lock in leadership accountability, and atrocities prevention efforts gained a foothold within the federal bureaucracy. I had the privilege of having the lead American job in building the International Criminal Tribunals for the former Yugoslavia and Rwanda, the Special Court for Sierra Leone, the Extraordinary Chambers in the Courts of Cambodia, and the Permanent International Criminal Court. All the Missing Souls is the story of this transformational moment in history about the creation and rise of 5 war crimes tribunals during the 1990s. That task occupied all 8 years of the Clinton administration for me, so I want to spend a few moments talking about my own role as it frames the personal part of the history in this book. I was the ambassador to hell, but also the ambassador to hell and back. In my more optimistic moments, I thought of myself as a carpenter of war crimes tribunals. The stark reality was that these courts would be the international community's frontal assault on impunity, and often had to begin their work amidst ongoing atrocities. My book is an insider's account. I tried to write what has not been covered in other books, but recognizing the rich body of literature that now explains many of these events. And I do stand in awe of the academics, journalists, and others who have written about the 1990s. But I come at this with a unique source of information. For 8 years, I took copious notes, and they're in many, many boxes, all neatly categorized. And that is the source that I drew from in the writing of this book. So you're really seeing information that simply is not conveyed elsewhere in the literature. And I also had the advantage of declassified State Department cables. You know, when you're in government when you're in the State Department, you spend half of your life drafting cables. And so when you come out and you want to look at the history of what you have done, of course you want to go back to the cables that you've drafted. During the first term of the Clinton administration, well, actually, let me just say, for 8 years, I worked for the most powerful woman in the world, literally, Madeleine Albright. First, as she was ambassador for the United States to the United Nations, and then secondly, she was Secretary of State in the second term. And it was an extraordinary privilege to work for her. She opened up these opportunities for me, and I had an extraordinary 8 years with her. But let me say about this book, you know, I started writing it immediately after I left government in 2001. Having been a political appointee and a Democrat, I was simply not eligible for employment in the George W. Bush administration, so I was on the street. And I left literally the State Department 10 minutes before he was sworn in on January 20th, 2001, turned in my ID, and that was it. I thought in the first year, I had a fellowship to the U.S. Institute of Peace, and I would sit down and write my book. After trying to do so for 5 to 6 weeks and looking at what I had written, I concluded that it was awful, just awful. I couldn't bear reading what I had written. And the reason is that I was very self-defensive. I hated the fact that I'd lost my job. I wanted it back. I didn't like the fact that we had lost the election in Florida, and I was angry with the Supreme Court. I was just angry. And so this was not a good attitude with which to write objectively your story. And so I just put it aside and retreated to something that I know the law professors in the audience will completely understand. I retreated to the safety and security of law review articles for many years, just started pumping them up, you know. And of course, started my academic career. But in 2007, I got a call from Princeton University Press and the editor-in-chief, Brigitte von Reinberg, who previously had been head of the history section of the press. So she was very, historically inclined. And she just said to me, David, isn't it time you wrote your book? I mean, what's going on? Where's the story of the 1990s? And I said, well, maybe now is the time to sit down and write. It was the best decision I ever made to delay. Because by 2007, I had had the benefit of reading what some other people thought about the 1990s, so I had more perspective of other people's thoughts and views and criticisms of the 1990s. And I also had calmed down. And I was just able, the moment I started writing, I found myself being able to be very self-critical and being very comfortable about it. So the book is a very self-critical examination of my own performance and of the Clinton administration's performance. So I do think that you will find what I hope is a fairly balanced approach to this. There are many, many failures discussed in this book. And in fact, even in the summary chapter at the end, I spend 3 pages summarizing the more prominent failures that I just discussed in the book, just so you get it, that we failed. I say all of that in the context of the person I admire so much, Madeleine Albright. There is so much in this book that I think projects the quality of her leadership and my pride in working for her. But I also had some disagreements. I had some tough moments, some very tough moments. And I write about those. And so you get both perspectives when you see this book. Now, I was on the Deputies Committee during the first term of the Clinton administration. For those of you who may not be that acquainted with the way the federal government operates on foreign policy decision-making, within the National Security Council, which is part of the White House, you have something called the Deputies Committee, who are the deputy secretaries of the major foreign relations related agencies like state, defense, intelligence, justice. The vice president's top aide is the deputy. And then there's us, the U.S. mission to the UN, which Madeleine Albright was the ambassador to. She had cabinet rank. So therefore, she needed a deputy on the Deputies Committee because she was then on the Principals Committee of the secretaries of the departments and Madeleine Albright and the National Security Advisor. That's the Principals Committee. I was her deputy on the Deputies Committee. So that meant that for 4 or 5 times a week, I was at the situation table in the White House on all of the major foreign policy issues of the Clinton administration, not just war crimes, but everything. And then I was there as her +1 during the principals meetings. So I was there all the time. I sort of memorized every panel of the Situation Room. That gave me an enormous insight and also, of course, responsibility as a policymaker for those first 4 years of the Clinton administration. And you see a lot of that in the book, particularly when I talk about the Rwandan genocide, about the Srebrenica genocide of '95, about the hunt for Karadzic and Mladic. A lot of these things were in the Deputies Committee because they're related to the tribunals. But I was there for so much more. That gives me sort of a unique perspective on how policies were actually being decided, which would ultimately have a tremendous impact on the course of international justice. I wrote the book, All the Missing Souls, over a 3-year period from 2007 to 2010, basically about 2.5 years. And that included then at the end a final 5 months for clearance within the U.S. government, 6 levels of clearance, as I understand ultimately, simply because as a diplomat you deal with an enormous amount of classified information, and you also sign a contract that if you're going to write about stuff, you got to turn it in for clearance, even in the aftermath of your employment. So I think you get in this book something that is a very, very authentic view of what occurred during those years, and one that I hope will stand the test of time. Now, what are we talking about in terms of international justice? I said a few moments ago that we were talking about a transformational period, really of the last 17 or 18 years. I think I can best explain that transformation by starting with what was the old world like. Of course, the old world was before 1993 when I took my position in the Clinton administration. What was that old world? Well, the old world had no international criminal courts whatsoever in it. None. The last we had seen was at Nuremberg in Tokyo after World War II, and those were international military tribunals. They didn't have civilian components, they were military tribunals. But they were bringing leaders to account in Nazi Germany and in Japan. So we had our first really major experience of doing that. But since those years, immediately following World War II, there had been a complete absence of international criminal tribunals from the international landscape. The Cold War is a major reason for that. Just imagine the lack of enthusiasm of either the Soviet government or the US government involved in the Cold War contest through proxy wars, etc., very little interest in actually holding themselves accountable for anything, and certainly not incentivized during that period, given the way the empires of the world were divided, to try to look at individual atrocities and bring individuals to account, since everyone was aligned with one side or the other. So we really had a huge gap of many, many decades with no international criminal courts to speak of. And that meant that when we arrived in 1993 with the Clinton administration, we were on terra nova. If the suggestion is being made, let's build an international criminal tribunal for the former Yugoslavia because the Balkans War is raging, the atrocities are comprehensive throughout the Balkans at that point, and the suggestion is, well, let's hold someone accountable for that. Before what? What court? Where? How? Certainly not before domestic courts. They're hardly functioning in this conflagration of the Balkans. You'd have to look to an international forum in which to consider accountability. Well, Madeleine Albright, in her early weeks at the UN, I think saw an opportunity to make a mark quite quickly, and I think quite constructively. And that was, let's take this issue by the horns and grapple with it. And we came up with a theory that we applied both in the Yugoslav Tribunal and then a year later in creating the Rwanda Tribunal to deal with the genocide of '94, of using the UN Security Council as the vehicle for creating an international criminal tribunal under its what we call enforcement authority under the UN Charter. This had never been done before. There's nothing in the UN Charter that says the Security Council has authority to build criminal courts. I mean, no one even said that in 1945 during the drafting of the UN Charter. So this was quite a leap, but Madeleine ran with it, and the French bonded with her in February of '93 to push this forward in the Security Council. And sure enough, by the end of February, on really warp speed basis, we had a resolution in the Security Council to build an international criminal tribunal. And then a few months later, we had a second resolution that was the operational resolution of how to actually build it. What's its statute going to look like? So I say all of that just to sort of introduce you to the notion, which I explain some in the book, that, you know, how do you approach an issue such as this when you have no standing precedent, and you really have to think out of the box how to create a criminal tribunal where none has ever stood before on an international basis, and with what authority to deprive someone of his or her liberty and ultimately, even permanently, their liberty through a conviction of life imprisonment. So no easy task, but that's where we began in February of 1993. But in that old world, as we were approaching this issue, not only were there no international criminal courts, but we actually knew so little about how to prosecute genocide. I mean, how do you do that? The Genocide Convention, no one had ever been prosecuted under it. Yes, there was Nuremberg, but remember, genocide was not literally at Nuremberg. It was crimes against humanity. We had the Eichmann trial in Israel, so that was our one example of a genocide prosecution. We had no real experience in prosecuting crimes against humanity, like ethnic cleansing. And we had very shallow experience in really prosecuting massive war crimes, other than Nuremberg and Tokyo. So with that lack of experience was also something we had to overcome in 1993 and '94 as we were building the first two of these tribunals. We also had really no body of international jurists to draw upon. I mean, who actually was out there that was qualified to prosecute these crimes and to judge them? And who was even qualified to be defense counsel for defendants charged with these crimes. There was no body of experienced international jurists. Madeline came to me very early in '93, just after we got the authorization from the resolution through the Security Council in late February of '93. And she said, David, look, in the entire history of the Permanent Court of International Justice, which then became the Court of International Justice after World War II, in which Judge Joan Donahue will speak here in early April, there had never been, she said, there's never been a single woman on the bench of the International Court of Justice in the entire history of that court. It's all been men making law for men. What is that all about? So she said, we are going to break that mold. Now, we're going to have the right, as the United States of America, to nominate someone for the bench of the Yugoslav Tribunal as a judge. I mean, after all, we're paying for this court. So we're going to have a judge on the bench. I want you to go out there and draw up a list of possible nominees by the United States, and then we'll decide which one we put forward to the UN for the election. Now, you can have a few men on that list, she said, but I want a lot of women's names on that list, a lot, okay? So my marching orders were set, and it wasn't that difficult at all, of course. I mean, there are tremendous women on the federal bench throughout the United States. So I compiled the list, and one woman in particular rose to the top of our consideration, and that was Gabriel McDonald, Federal District Court, Houston, Texas. She had run some great criminal trials, very authoritative, sonorous voice, just tremendous. We brought her to Washington. We were interviewing her, and she leaned over to me at one point in the interview, and she said, but David, you know, I really do not know anything about international law. and I leaned back and I said, you know, it doesn't really matter. It's okay. And I said, I've got some books for you. And I took down 2 or 3 treatises on international law, and I said, here, read these. They're yours. And I took down something on international criminal law, and I said, here, look, read this. It's yours. Chapters 6, 7, and 8, go for it. And she was a quick learner. And she ultimately, after she was elected to the tribunal, a few years later, she rose to be the chief judge of the Yugoslav War Crimes Tribunal as the president. She was the second president of the War Crimes Tribunal after Antonio Cassese. So that, you know, just sort of demonstrated that we had no real body of international jurists to draw upon in the old world, but somehow we got there. And finally, in the old world, we had official leadership impunity, literally. Now, in international law, as Professor Amen can probably dictate in her sleep, you have hundreds of years of doctrine in public international law on head of state immunity, on official immunity. If you're a leader, guess what? You've got immunity under international law. And there are lots of reasons for that. So even right up to 1993, if you're in policy discussions, and I was in them, you know, in the transition period in the State Department, January of 1993, as well as the early weeks of February 93, what was the crisis at that time, other than the Balkans, of course? It was Haiti, and this just flood of refugees heading towards Florida. That was the crisis. That was crisis management in the State Department at that time. When we sat around that table in the State Department trying to figure out what to do about Haiti, do you think we were sitting there saying, oh, well, let's see now, how can we bring General Cedros to justice for what he is doing to the Haitian people? I'm sorry, it was early '93. We were not discussing that. We were rather discussing, you know, what can we do to, you know, confront this refugee influx? And does anyone have a bright idea on how to get General Cedros to a nice villa in Panama for the rest of his life? I mean, that was the discussion. It wasn't, you know, let's bring this guy to justice. That was the old world. And if you look at the people of the old world who escaped any accountability whatsoever for unbelievable atrocity crimes between World War II and 1993. Just think of Pol Pot, Stalin, Idi Amin, Duvalier, Hafez al-Assad of Syria, Nicolae Ceausescu of Romania. Of course, we knew what his fate was. Mengistu of Ethiopia, Sukarno Suharto of Indonesia, Kim Il-sung of North Korea, Joseph Savimbi of Angola, Robert Mugabe of Zimbabwe, and of course we still got Mugabe with us. None of these individuals were facing even the merest suggestion of justice in 1993. And of course some of them have passed away by then too, never having been brought to justice. It just wasn't part of the dialogue at all. So that was the old world. Okay, the new world. And that's 1993 onwards. As we went through the 1990s, we were confronted with massive atrocities in the aftermath of the Cold War. I think this really shocked a lot of us. I mean, a lot of us in the United States and elsewhere in Europe saw the emergence of democracies in Eastern Europe, in the old Soviet Empire, the new independent states. These were moments of optimism, of new expressions of self-determination and democratization that we had never imagined on the world scene. And then in the middle of it, massive atrocities. What is that? What's going on here? Well, it was going on in huge dimension, whether it be in the Balkans, in many parts of Africa. These atrocities were taking place, and they were extremely disruptive of rational policymaking in the aftermath of the Cold War. So it really did jerk us back to some fundamentals that we brought with us from the Nuremberg and Tokyo era of how can you possibly allow the planners and executors of these mass atrocities to get a free pass. Doesn't this remind you a little bit of the reason for Nuremberg and Tokyo? And of course, there was a new pressure on the scene too. The non-governmental organizations, the NGOs, had started to reach a new and powerful status in international affairs, and they were bringing an enormous amount of pressure on governments to do something about this, to approach and confront accountability and try to discover it and implement it. That was a kind of pressure that hadn't existed in the 60s or 70s or even the early 80s. But that NGO pressure was there, and it was very, very strong. And NGOs were bringing information to the public far faster about atrocities than we had ever seen before. So we couldn't just sit there oblivious to this. So the building of these 5 tribunals began. Now let me just briefly summarize by saying in my book I have chapters on all of this. And then I have chapters on some other things that I want to talk about. But the chapters on the tribunals, you have the Yugoslav Tribunal, which was built in 1993, but really did not become operational until late 1994 in any realistic sense. And that the book explains, why it took so long to operationalize the Yugoslav Tribunal. It was for many reasons. There was a long, what was it? It was a 14-month journey to try to find a prosecutor for the Yugoslav Tribunal. If you don't have a prosecutor, you can't really start your investigations and get things moving without the leadership of the prosecutor in the office. So that was a huge delay in getting the tribunal up and running. But we also had challenges to the constitutional authority of the tribunal, et cetera, all of which had to be dealt with, all of which delayed the work of the tribunal. I tell of this, in my book about just this one issue, and I'll just diverge ever so briefly on this. In the Balkans conflict, we were rightfully criticized in 93, 94, and the first half of 95 for not acting more dynamically to stop the atrocities in the Balkans with some kind of military response. and I write a bit about this in the book. There's a tremendous amount about that story which I did not put in the book simply because the book had to be of a certain length and no longer. But I think there's a mistaken impression out there by so many very distinguished academics that somehow we built this tribunal as our excuse for not taking military action in the Balkans. In other words, oh great, you got a war crimes tribunal, job done, move on. We don't have to put soldiers on the ground. As if it were sort of our crutch for inaction. And all I can say is that being in the policy rooms at the time, that simply was not the case. And in fact, Madeline and I had to fight tooth and nail just to keep the minimal degree of support of our government behind the War Crimes Tribunal in those years. Other policymakers were more than happy to sacrifice the tribunal for some leverage, some concession by the Milosevic government. It was almost viewed as an easy give in order to get a nice concession during those long years of discussions that we had with the Milosevic government. So the book sort of describes how, in fact, it was a very difficult process of sustaining U.S. government support for the tribunal during those years. It was certainly not a process where policymakers are sitting there saying, oh great, we got to support this tribunal because it's our crutch for inaction on the military front. That simply wasn't the case. Okay, well let me just move on quickly by saying that the Rwanda Tribunal was 1994, and there's a chapter in the book about the Rwandan genocide where I describe the enormous mistakes that we made during that period. And then there are a couple of chapters about the actual building of the tribunal itself in the aftermath of the genocide. There is a chapter about Sierra Leone and the making of the Special Court for Sierra Leone, which was in the year 2000. That's when we negotiated it as part of right in the midst of the civil war in Sierra Leone. And that was the first instance where for a regional court, we looked at something other than a Security Council option. We looked at a treaty option to build that particular court with the government of Sierra Leone. And then there's the extraordinary chambers in the courts of Cambodia, which were negotiated from 1997 to 2000, and which are now operating. And that's a very long struggle of negotiation in the book that I think demonstrates to you just what happens when you have a very stubborn sovereign government, the Cambodian government, wedged in these negotiations with the United Nations as to how precisely to build a criminal tribunal to bring to account the Khmer Rouge leaders of the Pol Pot era. Very complex problem, the most complex I ever dealt with, and I'm still dealing with it, even today. And then there's the Permanent International Criminal Court, which I write 3 chapters about. And some of you know the term the Rome negotiations for the ICC. Well, there's a chapter about U.S. government policymaking before Rome, and then the negotiations themselves during Rome, and then a chapter about the post-Rome period, when we sort of recouped and finally ended up signing the Rome Statute of the ICC at the end of 2000. All of those are discussions about the give and take within the U.S. government, about the opposition within certain parts of the U.S. government to the ICC, and how as a negotiator I really had to, sort of track my way through a minefield of both support and opposition to the court within my own government. And I try to sort of tell that story in the book. Now, there are some other chapters. There's a chapter called Unbearable Timidity, in which I try to tell the story of the 5-year hunt for Karadzic and Mladic in the Balkans from 1996 through 2000. And we failed. At the end of the Clinton administration, we had not captured them. Why did that happen? What in the world was going on for 5 years that prevented us from achieving that core objective to remove from the scene in the Balkans the two top indicted war crimes fugitives. I think you will find in that chapter a story of painful frustration with my own government as well as with our partners overseas in Europe. And there's a chapter on Kosovo and the conflict that raged in Kosovo in 1998 and 1999. You know, for me, this was sort of the apex of my tour as a war crimes ambassador, because I finally had, first of all, the lessons of Rwanda and Srebrenica rather firmly embedded in my own memory bank. And then secondly, I really had all the agencies of the US government behind me. I even had the Defense Department, supporting me every single day during a period where mass atrocities were taking place in Kosovo, and we had to respond to that. We did so with a bombing campaign, and we also did so with a very, very dynamic atrocities watch that allowed me every single day to put the atrocities out front at the very opening shot of US policy every single day as the reason why we are engaged in this conflict with the Serbian government. Why are we there? Why are we part of a NATO effort that is bombing Serbia today? What is that? What explains that? What is our rationale, our justification for doing that? And for me, that was an opportunity to say, yeah, we've got a reason for doing that. It's atrocity crimes, genocide, crimes against humanity, and war crimes, and we're taking it seriously this time. And then finally, the book has some discussions of issues that are still with us very prominently today. You hear a lot about American exceptionalism. Now, that is a very large term, and I know even in the presidential campaigns, this term gets used an enormous amount. And it has a very large political context to it. In my book, I talk about it in one strand of that context, namely, what does American exceptionalism mean with respect to international justice and treaty making? How does it come into play with those issues? And I hope I demonstrate in the book that the argument of American exceptionalism is actually a very destructive argument when you're trying to advance US interests in treaty making. Think about it. When you enter a negotiating room, how are you going to persuade the other party to accept your position, to understand your interests, if you come in immediately saying to them, by the way, we're the exceptional nation, please stand down? It just doesn't work. It backfires constantly. I don't get it. I don't understand the rationale anymore. And I, of course, I had my own moments of walking into the room as the exceptional nation, barking out what I was instructed to bark out. And I think the book demonstrates how self-destructive that can be in a process as complex, for example, as the International Criminal Court negotiations. You need to be smart enough to walk into that room and figure out, how do I persuade all of them to come over to my side on this issue? How is that done? And American exceptionalism is not how it's achieved. So I try to tell that story in the book and suggest that we have important interests, we have important values that we want others to join us in. And we need a much more sophisticated strategy for how to achieve that internationally than what we see, particularly on the political front, when we hear politicians speak in the manner that they do about American exceptionalism. Let's see. Oh, okay. I guess I'm talking too much. Moving on here. I guess we start in what, 10 minutes?
Students may have to leave around 3:30.
Oh, okay, fine.
Maybe if we start.
All right, why don't we do this? I don't want to start Q&A quite yet, because one thing that I want to do is read just one passage from the book to you, because I think this will entertain you. This is this can often be seen as a grim subject, and I try to tell in this book a story of people, of personalities, and there's a little bit of humor in this book too. And what I'd like to do is, a lot of people ask me about my relationship with Madeline, and this is one little anecdote of life with Madeline in the early years. Albright displayed great cunning in her public service, and she brilliantly mastered both the Washington bureaucracy and the UN behemoth in New York. I marveled at how she could coax the most obstinate opponent into conceding vital points, while pitching over the cliff those who dared to presume that she, a woman in a man's world of diplomacy, had a weak spine. Some of my most enjoyable moments were when I played a bit part in her theater of misperceptions. During my early years with Albright, I would witness a group of men, and typically only men, enter her office at the State Department in Washington and plop down on comfortable couches for a policy meeting with her, while I sat on one of the hardback chairs to take notes and occasionally contribute a few words. Ambassador Albright would rise from her desk, greet the gentlemen, and ask if they wanted coffee. Invariably, some of the men would say, "Yes, please," and expect Albright to sit down with them and have either her secretary or me, the aide, serve the coffee. But Albright strode over to a side table, slowly poured the coffee, and brought each cup, one at a time, to the anointed men. Our first test was to see whether anyone objected to the U.S. Permanent Representative to the United Nations personally serving him coffee. Sometimes the men simply thanked her. The second test was to wait for one of the kind men to object and offer to help carry the coffee cups. But she would stop the poor soul and say cheerfully to the entire group, "Oh, please don't bother. You know, I used to do this for a living when I was a housewife." From that moment forward, Madeleine Albright controlled the meeting as the men sunk a bit lower in those soft couches. So I could read you another passage about Hillary Clinton, but we must get on to questions. So let's do that. Yes?
When you were coming up with the tribunals, how was it foreseen that private military corporations would take a larger role in war fighting and maybe committing some of these atrocities themselves?
You know, we confronted that issue of private military contractors being so prominent in these military operations. We confronted that most prominently only in the Sierra Leone situation, where, remember, executive action from South Africa had a long run in Sierra Leone. We actually had some serious discussion at the State Department table in 2000, in the policy tables, in the year 2000 about, is the only way we're going to get a grip on these rebels, actually this was in '99 when we had this discussion, is to just bite the bullet and try to get executive action back into play, you know, in Sierra Leone. So actually the discussion was really, in a sense, sort of pro-military contractor, but then the forces of reason prevailed at the table to say, my God, we cannot retreat to executive action in Sierra Leone. I mean, the executive action being the military contractor from South Africa, which had been able to discipline things in South Africa for many years, but had been withdrawn, and things deteriorated, not directly as a cause of that, but they did. We did not really discuss military contractors in the negotiations for the Rome Statute. Wasn't really a prominent issue of discussion at all. That is an issue that really came to the fore in the first decade of the 21st century. That's when it really emerged. It really was not a prominent issue in the 1990s. Just wasn't. Yes. Mm-hmm.
Go ahead. I got this
three-part question, but what actually constitutes an atrocity?
Oh.
Is it the number of
Yeah.
people that are killed, how they're killed?
Yeah.
Is it, and I want to ask you also, where is the fine line between somebody defending in their own mind, defending their country for what they believe in, and some of these hate crimes could go back several centuries
Yeah.
in time, and it's their turn to get back at these people for whatever they've done.
Yeah.
In their mind, they're justifying
Yeah.
what they've done.
All right, let's stop there because I'll forget them if you go to the third question. On the first one, there's a postscript chapter to my book, which is really designed for the general public as well as for law students and faculty and things of that people of that nature, which is where I explain the term atrocity crimes to sort of get a better understanding of what does this mean. It's not that complicated a concept. I don't think it's that unbelievable. It's the complex of genocide, crimes against humanity, and war crimes. What do we call that body of crimes? And I like to refer to them as atrocity crimes so that we have a simpler way of describing the totality of those crimes. But within that term, atrocity crimes is exactly what you just said. I set forth on page 429 of my book sort of criteria for what level of criminal activity rises to the description of atrocity crime. Not ordinary crimes, not ordinary felonies and things of that nature, but what rises to the level in terms of magnitude, of dimension, of context, of policy, origin, what rises to the level of atrocity crime. So instead of reading all that out, I'll just say that in the book there's sort of a description of how one looks at that issue. It's not precise. It's never going to be precise. Like, oh, does it mean 100 people die instead of 50 people? Of course not. I mean, that's not the way you calculate it. It's all depending upon the context of the situation, the conflict, and just the way in which the whole issue is being approached in that particular situation. But there is an attempt in my book to try to get at your question very, very directly. As to the other issue about ethnic hatreds and stuff, I think we have to be extremely careful about that issue. Part of the transformation that has occurred, and I really didn't get to this point, was the transformation is that we no longer presume official leadership immunity or impunity from accountability. I think the presumption at the policy table now is justice is on the table now. I mean, it is an issue. You cannot possibly talk about solving the situation in Syria without the factor of Bashar al-Assad's culpability and ultimate accountability for what is occurring in Syria being taken into account. You can't, you might have an option on the table, and it's a very fair option, of saying, let's get him out of there to a country of asylum, just so we get him out of there. You can say that. That's an issue. That's a viable option. Tunisia has offered him asylum, for Pete's sake. But you won't get through that discussion without some examination of the issue of justice, ultimately, for al-Assad, whether it's extradition from a country of asylum back to a newly constituted Syrian court system under a new government, or ultimately to the International Criminal Court or something. There's going to be a discussion at the table about his accountability, and that is the transformational development. Likewise, it simply is no longer, I think, plausible at a policy table to say, oh, the reason we've got this conflict is because there are ethnic hatreds. We've got to let them sort of fight it out because they've been doing it for hundreds of years. That is such an archaic way of looking at this problem. And in fact, I think we can even fault ourselves in the Clinton administration. I mean, the president himself read Robert Kaplan's book, Balkan Ghosts, which is a rather misleading view of this situation and saying, oh, it's been ethnic for so long, all these tensions, this is why they're fighting. Of course. No, I'm sorry. It's a different world now. If they're fighting, there's a responsibility to deal with that conflict, to stop those atrocities. There's not some pretextual excuse that because it's an ethnic conflict, let's just let the killing go forward. That's the old world. I mean, the transformation is we don't use that, and we shouldn't be using it as the basis for inaction.
I guess this is one specific example leads into another, but we had a speaker here you mentioned who wrote a book on Zimbabwe.
Yeah.
I can't remember what he was here a month or so ago. And I guess you mentioned it. One of my questions is with this new momentum, the new momentum coming with, bringing leaders to justice in Zimbabwe, you obviously have the Tabale massacres and recently the election massacre.
Yeah.
So why has there been so much inaction on that front? And
Right.
spinning out of that, how do you go about, I know they have to meet the requirements on the particular statute, whether they've committed these crimes, but I know there's so many considerations that go into it. For example, we deny indict Kim Jong-il because that would open up, a pretty significant can of worms. We haven't done anything, obviously, in Saudi Arabia.
Oh, yeah. Well, I think your question is basically why haven't we done it everywhere? Why? And it's a fair question, but also, recognize that so many of the jurisdictions that you just mentioned, we don't really have a court that has jurisdiction over Zimbabwe. We don't have a court that has literal jurisdiction over North Korea. The International Criminal Court, there are 120 nations that are party to it, and the court has jurisdiction over all of those 120 nations. All of America's allies are now part of the court, with the exception of Turkey and Israel. Every other ally is there, all of Europe, all of Latin America. But there are still pockets of the world that are not party to it, and a lot of that is in Asia and in the Arab world. And so that means that you don't have an automatic means of actually initiating a judicial response to, for example, what's happening in Zimbabwe. What court has jurisdiction over what Robert Mugabe does? There is no court that has jurisdiction today, other than Zimbabwean courts, and that's not going to go anywhere. So the one thing that I would just mention in terms of Syria is that just as with Libya and Sudan, which are not parties to the criminal court, the Security Council referred Sudan back in 2005, Darfur, and Libya last year, 2011, to the International Criminal Court for investigation and indictments, and that has happened. The next obvious candidate for that would be Syria today, and I would not be surprised if in the coming weeks you actually see the sole objective of referring Syria to the International Criminal Court by the Security Council, which would in fact activate the jurisdiction of the court over Syria, a non-party state, but this would activate that jurisdiction, a Security Council referral. I wouldn't be surprised if you don't see that happen with Syria soon. I think what would be negotiated is an abstention by Russia and China on that resolution. Remember, Russia and China both supported the referral of Libya to the International Criminal Court, even though they're not parties. Russia and China are not parties to the court. They joined with the United States in referring Libya. This might, if the fighting continues as it does in Syria, you get to a point of sort of implausibility and intolerance that I think would influence even Russia and China. I noticed just a couple of days ago, China has finally conceded the need to have some sort of humanitarian effort made in Syria. First time they've said it, that there's got to be some humanitarian response to what's going on in Syria. So week by week, I think this will get nudged a bit, and even Syria might be subject to some accountability. Yes?
When do you think the United States will join the court? And,
Yeah.
and is there pros and cons?
Sure, yeah. I mean, I dealt with this as part of my life for 8 years. I was the head of the U.S. delegation for the Rome talks, for the whole stretch of the U.S. negotiations at the UN on the ICC, right up to the last day in 2001. And there are obstacles to it. I think in a second term of an Obama administration, if he gets there, it still will remain problematic. There are other treaties that still take priority over the Rome Statute for ratification, and I could easily see the president simply saying, yes, there are treaties I'm going to prioritize, I'm going to get them ratified. The Rome Statute will have to wait in order to get these other treaties like the Comprehensive Nuclear Test Ban Treaty, the Law of the Sea Convention, the Convention against discrimination against women, CEDAW, the Child Rights Convention. All of these are prioritized way above the Rome Statute for Senate action. So just pragmatically, will we ever get there? But let me say this. I'm going to be rather bold here. I'm going to say that to some extent the United States has, under the Obama administration, achieved a certain level of de facto membership in the International Criminal Court. De facto. Now, why do I say that? The amount of cooperation between the United States and the court has risen dramatically under the Obama administration. There is great participation as an observer state in the Assembly of States Parties meetings, which are important. The United States had a huge delegation in Kampala, Uganda in 2010 for incorporating the crime of aggression into the statute, and was quite influential during those negotiations, even as an observer state. And it was appreciated that they were there and engaged. President Obama sent 100 military personnel to Uganda in October of last year to assist the Ugandan military to achieve one objective, and that is to capture and send to The Hague for trial before the International Criminal Court the 4 top indicted fugitives of the Lord's Resistance Army, including Joseph Kony. That is to implement an arrest strategy for the International Criminal Court, and our military is today engaged in achieving that objective. You can't imagine, as a prosecutor, do you think Ocampo enjoys having that assistance? You bet he does. And there are many, many other ways that the United States is actually now facilitating the work of the International Criminal Court. So, including our power on the Security Council. The United States led in referring Libya to the ICC last year. It was Ambassador Susan Rice. And believe me, she brought her memory bank of the Rwandan genocide with her into that job. I was working right across the table with her in 1994 during the Rwandan genocide. She was on the National Security Council at the time. We both remember Rwanda. And she was a very forceful leader last year in referring Libya to the ICC. And we can use our power on the Security Council to do that. So very important steps. And I would hope that within the next 10 to 15 years, my hope is that we can ultimately achieve membership. Yes?
When you have someone like Gaddafi who's been indicted and subsequently killed, before being brought to trial, what's the fallout at the tribunal level?
I'm sorry, I just didn't hear who you're talking about.
In the case where you have someone who's indicted and is subsequently killed before being brought to trial,
Yes.
Gaddafi, do you just wash your hands of it at the tribunal level?
Oh.
Do you breathe a sigh of relief? What's the fallout?
Oh God, no! You don't sigh. There's no relief. In fact, right now, the prosecutor Ocampo is in discussions with Libyan authorities over exactly how did Gaddafi die? Was he summarily executed? I think we mostly know that he was. And could anyone be held responsible for that in the militias that detained him at that time? No, I think any prosecutor with a degree of ego and vanity would want to have the privilege of prosecuting someone like Gaddafi once he's been indicted, of course, and he was indicted, and he died after the indictment. So no, I don't think there's any solace in losing an indictee through death in the field. You want that. Part of the whole point of these international war crimes tribunals is that they tell a story to later generations about what happened. You need the defendant in the courtroom to get that story out, to record it, ultimately to convict or acquit that individual, and try to establish the truth. It does no good for the individual to die. Milosevic, went through years of trial, and there was an enormous record achieved. It was a very controversial trial. A lot of people have criticized how it was run, etc. But the point is, it was a massive trial of Milosevic. He dies a few months before the judgment is going to be rendered. We lose that entire, well, we don't lose the entire, we have the trial record, but we lose the judicial assessment of the trial record through a judgment because Milosevic dies while he's on trial. So we all would have preferred that he live and have the judgment rendered, and that would be much better for history. Can I just say, I'm going to jump to one analog to what you asked. It is for that reason that I personally still have difficulty. I know it's extremely popular in the United States, and of course I'm going totally against the grain here. I could never win political office. But I do think I have a difficulty with the fact that Osama bin Laden was killed under a kill order. I mean, there was a kill order on him with the SEAL team. It wasn't capture or wound or kill if necessary. It was literally kill him when you see him. And for me, that's a problem, because I think if you're going to do justice, bring him back. He's under federal indictment. Prosecute him. Reveal the truth about this man in a court of law. And don't be so intimidated by the prospect of doing so. But that's not what transpired. Of course, he's gone now. But if I had had the chance to write that order to the SEAL team, I would have said, capture if possible, wound or kill if necessary in self-defense. That is your order. Use your judgment in the room, split second. That's what you're trained for. One more? Yes, Spencer, you're entitled to a question, Spencer.
So I guess it seems a lot of the problem or the issues you face is like line drawing.
Line drawing.
Like where to go, where not to go.
Yeah.
And what crimes to go after, what not. So I'm particularly interested in the Khmer Rouge, and it seems, who has the most say in the individuals that are pursued? Is it the prosecutor? Is it the local government?
Right. The Supreme Court chamber of the extraordinary chambers, which is the top appeals chamber, just ruled on this in its judgment on trial number 1 against Doik, who was the head of Tulsang prison, where about 16,000 individuals were tortured to death, tortured and then killed. And the Supreme Court chamber said that that discretion as to who should be fully investigated and then subject to to indictment is really the discretion of the prosecutors and of the what are called investigating judges of the court. In other words, it's not something that you take to the judges sitting on the appeals chamber and say, you decide where to draw the line. The judges said, no, it's not our job to draw the line on who is brought to us for trial. That's the discretion of the prosecutors and, in this unique court, of the investigating judges. Now, in the American system, the U.S. attorney, it's his discretion or her discretion as to who is actually indicted. And so or who's brought to the grand jury, et cetera, for that determination. So it is a very, very discretionary instrument. Now, what we did in these tribunals was we wrote into the statutes of each tribunal the personal jurisdiction requirements, and it is different from one tribunal to the next. The Special Court for Sierra Leone says, the discretion only extends to those who have the greatest responsibility for the atrocities, the leaders who are at the very top of the pyramid. That's who we're going after. For the Cambodia Tribunal, we said those senior Khmer Rouge leaders and others most responsible. And I write in the book, as we were negotiating the statute for the Special Court for Sierra Leone, we had already settled on the language most responsible for the Cambodia Tribunal. And then we spent weeks negotiating, well, should it be the word most or the word greatest? Now, is there a difference between those two? Please describe the difference in terms of Oxford Dictionary rationale. And by the way, where would that line be drawn between most responsible and those with the greatest responsibility? It became almost farcical, our discussions. But indeed, we settled on the greatest responsibility for Sierra Leone, thinking that term really did create a very, very narrow category of individuals who would fall within the jurisdiction of the court.
I'd like to thank Professor Scheffer, let you know that there are books of his available at the table. He may have a few minutes to sign books if any of you would like, and to chat otherwise personally. But for now, I'd like to close this part of the session and give Professor Scheffer a hand of applause for his talk. Thank you.
Thank you.